All rise. The Supreme Court of the Paralegal Cup is now in session. You may be seated.
I'd like to congratulate the two finalist teams on getting this far. The appellant, is the appellant ready? Yes, sir. Anytime you are.
Good afternoon, Chief Justice and members of the court. My name is Phillips, first initial G. To my right is my colleague, Brklacich, first initial K. We are here representing the appellant crown in this matter. Before I begin, would your honors like a brief summary of the facts?
Not for me.
It's not necessary.
No,
Thank you, your honors. The appellant's position is that the Court of Appeal erred in applying the analysis established in the Supreme Court of Canada case Regina versus Moran and made an incorrect inference of prejudice. Therefore, the Crown seeks to have the stay overturned and the trial judgment restored. To this effect, the Crown will be making 3 submissions. Firstly, that the Court of Appeal incorrectly applied the relevant case law to the case at bar, causing a permissive inference of prejudice to become a mandatory presumption of prejudice. Secondly, that this mandatory inference fails to take into account other relevant factors established by the case law. Thirdly, that society's interest in having the case at bar tried on its merits far outweigh Mr. Williamson's individual rights.
Sorry, can I just stop you, counsel? You're just talking too fast, and we're trying to actually keep up. Can you restate the second and third points again?
Very well, Your Honor.
Thank you.
Our second submission is that this mandatory inference of prejudice fails to take into account other relevant factors established by the case law. And thirdly, that society's interest in having the case at bar tried on its merits far outweigh the accused's individual rights.
So you think the Court of Appeal applied the mandatory version of the test?
Yes, Your Honor, that is our submission.
Well, then you have to agree that the trial judge also applied the wrong test because he also found inferred prejudice.
He did find that there was inferred prejudice, but the Court of Appeal erred when they stated that based on cases having similar delay, that significant prejudice must be inferred.
Okay, so it's the significance of the prejudice that was inferred that you think the Court of Appeal got wrong.
Yes, Your Honor.
But you agree that given enough weight to enough factors in favor of the accused, that at some point it's unavoidable to find significant prejudice, do you?
Your Honor is correct, and the Supreme Court of Canada case law bears out that as delays become overly long, it creates a virtually irrebuttable presumption of prejudice. Eventually, delays do indeed get too long. But, Your Honors, the Crown would submit on this case, on these facts, the delay has not been so long that it warrants a stay of proceeding. That the prejudice to Mr. Williamson, the weight of it, was not so great that it outweighs society's interest in having the case tried on its merits.
But the delay is 35 months, correct?
The delay is
That's a
35 months, that is correct.
So on its face, that's a significant delay. So I'd like you to address why you say 35 months is not, on the facts of this case, so significant.
In order to answer Your Honor's question, I will begin by assessing the factors relevant to the inference of prejudice in this case, because I take it that your question relates to how much prejudice can be inferred from this delay of 35 months. Would that be correct?
No, I'm simply suggesting that on its face, 35 months is a significant delay. But your opening comment was that taking into account the factors of this case, we ought not to consider it so significant a delay as to invoke the 11B. So I'm asking you to simply tell us why, or what factors there are that you think ought not to, or we ought to take into consideration to say that 35 months isn't on its face a significant amount of time.
Very good, Your Honor. May I have a moment?
You may.
The inference of prejudice that may be drawn, as established by the case law, is not meant to be drawn from thin air. It is real harm to the accused's interests established by the Charter. However, we must have some facts in the case that give rise to this inference of prejudice. And in this case, I shall point out some of the factors of actual prejudice and then discuss that the inference that we must draw in the absence of some of the factors that normally would give rise to prejudice is a lack that thereof. In this case, the accused was not fired from his job. He was, in fact, given his full pay for the duration of the period between the time that he was charged and the time that he was brought to trial. He imposed by himself a condition of house arrest that he did not leave, and he was, again, out on bail and experienced no significant media scrutiny. In this case, what could we, or I should say, what ought we infer from these facts? Mr. Williamson was not experiencing anxiety relating to money, was not experiencing anxiety related to his employment or his status in that case, and his being cut off from the community, as he alleges in his 11B application, was self-imposed. He did it to himself.
Are you suggesting that because somebody is paid, so in this case, Mr. Williamson's on a paid leave pending the outcome of the trial, are you suggesting that merely because he's paid that he hasn't suffered any prejudice at his job? Are there not other elements to one's job that go to the heart of one's self-worth that have nothing to do with the monetary aspect of the job?
Your Honor, it is not the Crown's submission that Mr. Williamson experienced no prejudice. Merely that the weight of that prejudice is not so significant to outweigh society's interest. In this case, on these facts, we find that he, and I shall point out that he was on paid leave. Had he been found innocent, had the charges been cleared up, he would have returned to his job. It was not uncertainty about that portion of his life that gave rise to anxiety. It is open to the court to infer this prejudice. The Crown merely submits that based on these factors that are present within Mr. Williamson's case, that inference should not be drawn, or if it is drawn, that it is not significant prejudice, even given the overly long delay. We would also submit that if this court were to dismiss this appeal, it would be to do away with many of the guidelines established in case law and set a new guideline. It would be to set a limitation period, if you will, on bringing cases to trial. It would be to say that after X number of months pass, so much inferred prejudice exists that we simply cannot justify in any circumstances proceeding with the case. And I would submit that this is not the inference that the case law calls for us to make. Going to the heart of the matter, the delay, there are other factors present in this case that point toward the delay be having an explanation, and they must be taken into account as established in Regina versus Morin. Trial judges must be permitted to consider the facts before them, after all.
Go on.
Your Honor, I notice I am running towards the end of my time. May I have 2 additional minutes to conclude my submissions?
Of course.
Thank you, Your Honor. In the case of Mr. Williamson, a sudden and temporary increase in the use of the resources in the District of Kingston arose. There was a multiple murder trial with multiple accused taking place in one of only 2 courtrooms that could support a jury trial in Kingston. This took up a significant amount of the court's resources, and the case law calls for us to take this significant use of resources into account.
All right, let me stop you there. I think the other side would concede that the trial judge adequately explained the reasons for the delay. But the Court of Appeals' criticism of the trial judge has to do with his failure to justify the delay. For example, why wasn't the Crown interested in moving the trial somewhere else?
May I have a moment, Your Honor? Your Honor, at this point on the record, no evidence was submitted to the effect that the Crown did not wish to move the trial to another venue. Not to speculate, but it may well be that things were tried and that they failed. And in this case, the case law in Regina versus Morin tells us to take into account the provision of judicial resources in regions like Kingston. It states that sudden and temporary strains on resources, such as the one experienced in this multiple homicide trial, taking up a significant amount of resources, should not result in an amnesty for all persons charged in that region. These things happen, and we must do justice in the real world. We do not live in a world of infinite courtrooms, infinite judges, and infinite courtroom staff to hear these matters.
But do you dispute the Court of Appeals' conclusion that there were available resources in other parts of the region, for example, in Ottawa? And if you don't dispute that, then you fail to justify the delay. And the failure to justify the delay drives the discretion in favor of the accused, doesn't it?
The Crown would dispute the findings of the Court of Appeal in this case. The Court of Appeal seems to state that simply finding a courtroom in another jurisdiction is as easy as making a phone call. But in this case, Your Honor, there is much more involved in changing the venue of a courtroom. Schedules of other jurisdictions, the provision of Crown attorneys and resources.
But we don't know whether those things were obstacles in the way of a trial somewhere else. Aren't you just speculating on the possible reasons for not moving it somewhere else?
Justice Rennie, let me take this in a different direction, if I may. Let's assume that we accept your position that the resources, that it couldn't have been done, that resources perhaps weren't available. It wasn't as easy as a telephone call. Then doesn't that bring us back to Askov, which says that, in fact, you can't necessarily visit upon the accused the lack of the Crown's ability to bring the case to trial in a timely fashion?
May I have a moment to consider your question, Your Honor? Your Honor, in answer to your question, the Crown would concede that it is indeed the onus, the burden of the Crown to bring accused to trial. It is the state, after all, that must do these things. We would only ask that the court take into account the limited resources that were available to Kingston at the time, as the case law supports that you do.
So your position really is that the Court of Appeals speculated that there were available resources somewhere else, and that it ought not to have speculated itself. Is that your view?
Yes, Your Honor, it is. In this case, on these facts, we cannot necessarily make out significant prejudice to the accused. And the Crown would submit that in having this case tried on its merits, we would benefit society's interest more, that the weight of the prejudice against the accused was not so significant to outweigh the extremely important societal interest in having the case at bar tried on its merits. Barring any further questions, Your Honor, those are my submissions.
So, can I ask one more question? So are you suggesting that if the charge were something less than this charge, are you conceding that in those in certain circumstances, then the 35 months would clearly be excessive and should result in an 11B dismissal?
In certain circumstances, Your Honor, yes, there could be a situation in which an 11B dismissal was warranted, but the Crown would submit that it is not on these circumstances in Mr. Williamson's case.
I have a question. Given that there were only 2 courtrooms and the other multiple murder case was going on, would you not agree that that case probably should have been risked on 11B and not this one?
Your Honor, I noticed that the timekeeper has called time. Would you like me to answer your question?
Yes.
Yeah, don't let the timekeeper dissuade you from answering the question.
Thank you, Your Honor. If I understand Your Honor's question correctly, the question is, was there a certain weighing of society's interest in the multiple homicide case versus this one? I would submit that each case must be looked at on its individual circumstances and decided on that basis. I would not speculate as to whether or not the Crown Attorney's Office would weigh those one case against another.
But isn't the nature of the crime here in the Williamson case far greater for punishment and society's interest than the multiple murder?
Again, in this case, Your Honor, I would submit that we cannot know what weight that these cases have in terms of society's interest if we consider them in relative terms. We can only assess each case on its own merits. And in this case, we are dealing with a young boy who was taken advantage of, allegedly. And that merits society's great interest. So too does a multiple homicide. It does not, one does not diminish the other.
Thank you.
Thank you, Your Honor.
Thank you.
You had indicated submission with respect to setting out new timelines that for to accept position that 35 months would be the new timeline and new precedent. Yet, isn't it true that Morin says that the guidelines should be dealt with on a case-by-case basis?
Yes, Your Honor. In my submission, I did state that the Morin guidelines state that we need to look at every case on a case-by-case basis. My submission was that by saying that based on cases having similar delay, as the Court of Appeal stated, that we must infer significant prejudice, it would have the effect of setting a new guideline. That if we look at cases only on their similar delay, that we must infer significant prejudice, Your Honor.
Thank you.
Sorry, I do have one more question for you. Going back to Ms. Lipa's question, are you saying, counsel, that the seriousness of the accused charge in this particular case supersedes or outweighs an individual's charter rights?
I would state, Your Honor, that the case law calls for us to take the seriousness of the charge into the balancing act between the individual's interest in their rights and society's interest, collective interest, in having the case tried on its merits. Barring any further questions.
Thank you very much
Thank
for
you.
indulging us in
Thank you.
in a myriad of questions that we had. Maybe we should have timekeeper for questions from the bench, too. Case can be very made.
Thank you for all your questions, Your Honors.
Anytime you're ready.
Good afternoon, Chief Justice, members of the court. My name is Brklacich, spelling B-R-K-L-A-C-I-C-H, first initial K. And I represent the appellant Crown in the case at bar. I have one submission to make today. It is the Crown's position that society's interest in hearing the case at bar tried on its merits greatly outweighs Mr. Williamson's individual interest under Section 11B of the Canadian Charter of Rights and Freedoms. Mr. Williamson has been charged with over 50 counts of buggery, gross indecency, and indecent assault. These are crimes of a sexual nature that were allegedly committed against a young boy with whom he had a mentor relationship through a Big Brother type program. This was a fiduciary relationship. Up until the time of his arrest, Mr. Williamson continued to hold a position of trust within our community as a school teacher, trusted with caring for youth on a day-to-day basis. We submit that this is why society has a particularly special interest in hearing the case at bar tried on its merits. After all, the public wants to know that someone who has been charged with crimes as serious as these is brought before the courts to answer to the charges.
But the other side can argue that society also has an interest in preserving the charter rights of individual accused. By emphasizing the seriousness of and the nature of the offense as you are now doing, aren't you running the same risk as the trial judge ran? The risk of oversizing the weight to be given to seriousness? After all, it's just one factor to be considered among many. The Court of Appeal said that the trial judge use of seriousness was conclusive and that it ought not to have been. Aren't you running the same risk?
Thank you, Chief Justice. We would submit that the seriousness of the charges is but one factor to consider. The test set out for assessing whether or not a delay has been unreasonable is given to us in Regina versus Moran. In balancing society's interest, we must recognize two things, exactly what you stated. Yes, society does have an interest in seeing that individual charter rights are upheld. However, in the Supreme Court decision of Regina versus Moran, we are told that as the seriousness of the offense increases, so does the societal demand that the accused be brought to trial. In balancing which way the scales tip, we must look to any prejudice that the accused suffered while awaiting trial. In the case of Mr. Williamson, we submit that there is no significant prejudice that can be determined.
I think the other side will probably concede that the seriousness of the charge weighs in favor of the Crown. But aren't the other factors all weighing against the Crown in favor of the accused? The very factors that the Court of Appeal found wanting in the trial judge. For example, the straightforwardness of the case, the fact that the trial judge failed to justify, not only explain, but failed to justify the Crown's delay, the trial judge's failure to see significant inferred prejudice when he did not. Don't all the other factors go in the other direction?
We submit, Chief Justice, that in the Ontario Court of Appeal decision, there was not enough weight given to the reason for the delay. Again, that is but one factor to be considered when applying the analysis set out in Regina versus Moran, that we must look to the reasons of the delay. In the case at bar, there was, as my colleague has alluded to, a significant case that was occurring in Kingston at the time. This used an enormous amount of resources. There's only 2 courtrooms in Kingston that could have housed a judge and jury trial. Furthermore, this was a temporary strain on resources, and the test set out in Regina versus Moran calls for flexibility. It is reiterated on multiple occasions that the guidelines are exactly that. They are guidelines.
Just on that point, do you say that the Court of Appeal was wrong in taking judicial notice of the fact that there were available resources in other places of the region? Do you find fault with their taking judicial notice of that?
We submit, Chief Justice, that the Court of Appeal was not necessarily wrong in taking judicial notice. However, it was very speculative. We do not know exactly what could have happened. We do not know exactly if the case could have been moved to another venue. Having something like a judge and jury trial shifted from Kingston to perhaps Ottawa, as you suggested earlier, these things do not happen overnight. It is not something that can be arranged and organized at the drop of the hat or a snap of the fingers. These things take time, they take coordination. And what was happening in Kingston at the time, the strain that the Crown was under, was but a temporary strain on resources. And we submit that in assessing all of the factors in the test of Regina versus Moran, and the lack of significant prejudice, and the reasons for the delay, and the seriousness of the charges.
In your factum, you make the argument that the Court of Appeal ought not to have taken judicial notice of available resources elsewhere because they weren't local judges. They didn't know enough to know the local conditions elsewhere in the region. Isn't the Court of Appeal, as a provincial judge, as a provincial court, having jurisdiction across the province, isn't the province for the Court of Appeal their local courts? In other words, why would you say that they don't know local conditions when it's part of their mandate to know province-wide what resources are available in Section 11B cases?
Absolutely, Chief Justice. This is but one of the reasons that we have the Court of Appeal. However, we submit that there is no point in time in which a particular court can say these are the conditions in that district at the time. The conditions in a particular district are ever changing. They can change from one month to another. And we submit that the Court of Appeal made a very broad and general sweeping speculation and put too much expectation on the Crown to just have the resources and the ability to change an entire judge and jury trial in such a short manner of time.
You seem to be putting a lot of emphasis on the other murder trial, but in fact, the Crown itself delayed earlier on. Isn't that true?
Yes, Your Honor, there were 2 occasions when a preliminary inquiry was delayed. It was adjourned. The Crown submits that this was a very misfortunate misunderstanding. It was not an attempt to further delay Mr. Williamson being brought to trial. We do justice in the real world, and mistakes do happen. Furthermore, Mr. Williamson was offered 2 opportunities to have an earlier date for preliminary matters, and he declined both. So yes, there is blame to be given to the court. There is weight to be given to the 2 preliminary inquiries that were adjourned. We recognize that. However, Mr. Williamson, on 2 occasions, did also have the opportunity to perhaps bring this matter to trial a little bit faster. And we submit that if he was suffering significant prejudice to the point that he is claiming, perhaps he would have taken the Crown up on but one of those offers.
But that doesn't that, but that now you're doing what you're asking us to. You're suggesting the Court of Appeal is speculating, but now you're doing the same thing. If in fact Mr. Williamson had availed himself of those opportunities for an earlier trial date, or to put it another way, perhaps he didn't do so because he felt he might have been prejudiced, as they wouldn't have been ready to go to trial. So aren't you now sort of saying, you're doing the same thing that you're asking us to, sort of slap the Court of Appeal for doing, which is speculating?
Correct, Your Honor, that this is a speculation. We do not know exactly what would have resulted had Mr. Williamson accepted one of these earlier dates for a preliminary matter. He could have gone to trial at the same time as he did. This we don't know. Hindsight is always perfect. We don't know. However, what we are submitting this for, what we are asking you to consider by submitting the fact that he did not take any of the earlier preliminary dates afforded to him or offered to him, is that if he was suffering prejudice to the degree that he is claiming, it's reasonable to conclude that to minimize this prejudice, that when presented with the opportunity to perhaps speed this trial along, he would have taken us up on that.
All right, so you're spending a lot of time telling us about why we ought not to consider the prejudice as a result of the delay because of the judicial resources or lack thereof. But I think it was either you or your colleague that said that there was no real prejudice inferred, no real prejudice should be inferred as a result of the bail conditions. Did I understand that correctly?
Our submission is that to date, no court has found that Mr. Williamson suffered any actual prejudice.
Right, but there's an inferred prejudice, and the mere fact that he was on bail for 35 months would seem to me to imply it's not unreasonable for the Court of Appeal to have inferred prejudice.
Absolutely, we do agree with that. When anyone is charged with a criminal offense, there is a certain amount of prejudice that we can infer from the nature of the charges themselves. In Mr. Williamson's case, it was very serious charges. We do not dispute that there is prejudice that we can infer. However, what we are submitting is that in the delay of him being brought to trial, that prejudice did not become so overwhelming to the point of the significance that he is claiming. In regarding to his bail conditions that you mentioned, Mr. Williamson was afforded much more lenient bail conditions than many people who have been accused of a crime and are out on bail. The only real restriction in his bail conditions was that he could not be in the presence of someone under the age of 16, which, given the nature of the charges, it's really not difficult to understand why that restriction was imposed. Mr. Williamson was free to move about in society, to do what he wanted. He could have gone and got another job if he found that he was spending too much time at home. There was nothing in the bail conditions that we can infer contributed to a significant amount of prejudice.
Well, you're really suggesting that a man that's on bail, awaiting trial for charges of this nature, could easily have gone out and found another job? And could not the term of the bail, in terms of interacting with people under a certain age, could that not have put him inadvertently, merely by being out and about in society, he could have inadvertently found himself in breach of his bail conditions? And that maybe, in fact, what you refer to as a sort of self-imposed house arrest was actually wise on his part. And therefore, in my mind, I don't necessarily think it's wrong to infer the prejudice. So can you answer that for us? I'm open to being persuaded, so please go ahead.
Thank you, Your Honor. Mr. Williamson stated that the most detrimental aspect of that bail condition was that it restricted his ability to continue a relationship with his nephew. He stated that this was very emotionally distressing to him and that it had a great effect on his life. However, Mr. Williamson was told that he could have applied to the courts to have this bail condition varied so that he could maintain the relationship with his nephew if that was so detrimental to his life. He did not do so. His brother was unable to come to Kingston to attend court to have this bail condition varied. When he informed the courts of that, he was told that a simple signing of an affidavit would allow him to. I notice that I'm out of time. May I continue with my answer? Absolutely. As I stated, a simple affidavit could have altered this bail condition. However, for whatever reason, that was not able to be done.
Okay, thank you.
I have a question.
Absolutely.
If we accept that the Court of Appeal got it right with respect to the inferred prejudice causing the infringement of Section 11B of the Respondent, what's your position to applying Section 1 of the Charter with respect to that argument? Are you familiar with Section 1?
Yeah, may I have a moment just to consider
Yes.
your question? Thank you. To address your question, Your Honor, in respect to Section 1 of the Charter and applying that to any significant prejudice that we can infer resulting in a stay, that we submit that under Section 1, given the seriousness of the charges brought against Mr. Williamson, that the stay of proceedings granted to him does not warrant a reasonable limit. That this is not, it doesn't guarantee that it does not fit within the rights and freedoms set out that are subject to reasonable limits, and that the seriousness of the charges weigh heavily in the favor of society of having the stay overturned.
So I'm not sure if I'm following you. Are you agreeing that Section 1 would be helpful?
Yes, Your Honor. Thank you.
Thank you.
Okay, if you concede that, don't you also need to concede that the Crown doesn't need to justify under Section 1 because the Section 1 analysis is embedded right into Section 11B? We're doing a Section 1 analysis within 11B where we're balancing the proportionality of the seriousness of the offense versus the protection of charter rights. So is it your view then that there is no recourse to Section 1 because the same considerations are being dealt with under the common law under Section 11B? I think you're safe to concede that. For the Crown.
Thank you, Your Honor.
I was just helping you out.
Thank you. Barring any further questions, that concludes our
Very good, thank
submissions.
you.
Thank you.
Yeah. ready?
Yes, I am.
Anytime.
Good afternoon, members of the court. My name is Lorestani, initial J, and to my left is my colleague Tang, initial C, and we are here on behalf of the respondent, Mr. Kenneth Gavin Williamson. It is our position that the trial judge erred in refusing to grant a stay of proceedings based on his application of the Supreme Court of Canada decision of Regina versus Morin and Regina versus Godin, and we are requesting the court to dismiss this appeal and uphold the Ontario Court of Appeal decision. We have two submissions to make to the Honorable Justices today. Our first submission is that Mr. Williamson suffered significant prejudice, which can be inferred by the delay of getting this case to trial, and that the trial judge did not allot appropriate weight to the factors of prejudice that can and must be inferred in this matter.
Before we go to the second point, I just
course.
want to be, so that we're clear. You're not raising before this panel actual prejudice, you're simply suggesting it to be inferred based on the various factors, correct?
Yes, Your Honor.
But there's no specific evidence before this court about actual prejudice, is that correct?
Correct, Your Honor.
Thank you.
Thank you.
Sorry, you go to your second point.
Thank you. Our second submission is that Mr. Williamson's right under Section 11B of the Canadian Charter of Rights and Freedoms has been blatantly violated, and society has a strong interest in upholding an individual's charter rights. I will be addressing our first submission regarding prejudice that must be inferred to Mr. Williamson as a result of the delay, and my colleague will address balancing society's interest in this matter. To begin, there is significant prejudice that must be inferred as a result of the excruciatingly lengthy delay. In this case, when analyzing the security of the person interest inherent to Section 11B of the Charter, it protects more than just the physical integrity of Mr. Williamson. It protects Mr. Williamson's individual rights against, as stated by Justice Lemaire in Regina versus Mills, as quoted in Regina versus Ashcroft, the security of the person interest recognizes the need for the protection of more than just the physical integrity of the accused, thereby providing a safeguard against the overlong subjection to the vexations and vicissitudes of a pending criminal accusation. These vexations were present during the course of the 35 months that Mr. Williamson waited to get to trial. That's over 1,000 days. Mr. Williamson, in this 35-month period, could not go back to work. He paid a tremendous amount in legal costs. And this happened because the Crown failed to contact the defense counsel. This is a clear illustration of prejudice that must be inferred as a result of this delay.
All right, let me stop you there.
Of course, Your Honor.
You're focusing quite heavily on how the delay affected the accused on a personal level. You're right to do that. You're not wrong to do that. But what you're doing as a respondent really is to disagree with the amount of weight the trial judge placed on inferred prejudice. Isn't the trial judge entitled to deference on inferred prejudice? That is a finding of fact. Isn't the trial judge's weighting of the stress of the inferred prejudice isn't the trial judge entitled to be wrong within limits, within reasonable limits? You and the trial judge may disagree on how much proper weight ought to be given to the stress and the anxiety of having to wait for one's trial. But isn't the trial judge entitled to be wrong so long as his weighting is just as reasonable as yours?
Respectfully, Your Honor, in the case in the Ontario Court of Appeal, the Ontario Court of Appeal assessed the factors of prejudice, assessed the Regina versus Morin test, and found that the trial judge did not factor appropriate weight to the analysis of prejudice, of inferred prejudice.
I understand
in this matter.
that, but why should the Court of Appeal substitute its own decision for proper weighting of inferred prejudice in substitution for the trial judges? Why should the Court of Appeal be allowed to second-guess the trial judge?
They have the authority to do that, Your Honor. It was outside of the reasonable limits.
Oh, so that's your position. You're
Yes.
saying that the trial judge's finding of inferred prejudice was unreasonable?
Yes, Your Honor.
Okay, so now tell me, in what way was it unreasonable?
May I have a moment, Your Honors? Thank you.
I mean, that's the heart of the case, isn't it? The standard on appeal is palpable and overriding error. That's a very high, stringent standard. It's very high because normally a lot of deference is given to trial judges. But the Court of Appeal is entitled, isn't it, to set aside unreasonable findings of fact. And are you saying that the trial judge's finding of unreasonableness was in failing to consider those Court of Appeal precedents that found significant prejudice, like Steele, for example? Is that your position?
Yes, it is, Your Honor. In the example of Regina versus Steele, which is where the Ontario Court of Appeal it was one of the precedent cases to decide that there was significant prejudice in the matter. In Regina versus Steele, what happened in this case, if you could just bear with me a moment here. In Regina versus Steele, they had found that the reasoning, the explanation, and the justification for the reasons behind the delay was unsatisfactory. This is exactly what we have here today. The reasoning behind the unreasonable delay of 35 months is inexcusable. The Crown, under Section 11B of the Canadian Charter of Rights and Freedoms, had a positive obligation to uphold Mr. Kenneth Gavin Williamson's charter rights. They failed to do that. In Regina versus Ashcroft, it explicitly states that they must look to temporary facilities. It asks them to get creative. The Crown at the case at bar did nothing.
Well, I wouldn't quite put it like that. The Court of Appeal said that the Crown didn't give a trial as much priority as the accused gave it. But there again, you're quibbling over the amount of weight that was given to priority. You're disagreeing on, what you're saying is that the Crown didn't give enough priority to this case. It certainly didn't match the priority that the accused put in his own trial. But once again, why should the Court of Appeal interfere with the trial judge's reasonable assessment on the issue of priority? Why should we interfere with the trial judge's view on that?
May I have another moment, Your Honors? Thank you. The reason that the trial judge was incorrect and there was an error in his analysis was due to the fact that he did not consider the reasons for the delay. He did not allot the appropriate weight to inferred prejudice. It is not that he disregarded inferred prejudice. He very well understood that there was an inference of prejudice as a result of the delay. However, in the case at bar, he did not give it the weight that it deserves. It is inherent to Section 11B of the security of the person interest. It includes factors such as the stigma of the accused, the stress that they suffer, the anxiety that they bear. And we can only infer that after 35 months, the anxiety is evident, the stress is evident, and we do not require tangible evidence to prove this. This is a real feeling, this is real. Yes, Your Honor.
No, finish your thought first. Go ahead, and then I'll ask.
This is real evidence.
Well, so you just said you don't require tangible evidence because the nature of this is such that we should reasonably infer it, is what you're saying.
Yes, sir.
But you could have, presumably, before the trial judge, brought evidence of real prejudice. Could you not have done that? And I appreciate that you weren't trial counsel, so I don't mean to be harsh, but could not Mr. Williamson's trial counsel, in addition to arguing the 11B argument on inferred prejudice, could trial counsel not also have brought real evidence of real prejudice, as opposed to simply asking us to infer it? And I appreciate that the law may not require that, but it certainly could have been done, could it not?
We submit that it could have been done, but it does not become relevant in assessing prejudice in this case. Regina versus Moran states that the lack of action from an accused does become relevant when assessing the degree of prejudice, but in the context of Regina versus Moran, for example, the Crown made an attempt to contact defense counsel. They tried to get the Miss Moran a faster, an earlier trial. In the case before you today, the Crown did not do that. They did not carry that positive obligation.
So your argument then hinges on the lack of action on the Crown side at the trial level, correct?
Correct, Your Honor.
Thank you.
Our friends mentioned earlier that if the court is inclined to infer that there must be prejudice in this matter, that it will place a judicial cap. We submit that we are not asking for the court today to place a judicial cap. This is a case-by-case analysis. When we go through the 4-step test in Regina versus Moran, the length of the delay is 35 months. The reasons for the delay are inexcusable. It is not justified. They had 10 courtrooms in their jurisdiction that they could have called.
Are you asking us to ignore the 2 opportunities that your client had to bring this matter forward and chose not to?
Respectfully, Justice, in those 2 instances, Mr. Williamson had a family matter that was very urgent. He could not attend the pretrial conferences that were being provided to him at earlier dates, but we cannot speculate that if he was given those earlier pretrial conferences, that he would have received an earlier trial. It was 2 instances, and that 2 months has already been attributed to the defense, and we acknowledge that, we accept that. But when we look to the institutional delay and what's been allocated to that delay, it was 26 months. That is 13 times longer than what the defense attributed to the delay.
Yeah, while you're on this topic, let me pose a question to you that I posed to the other side, except that it was the reverse. Do you say it was right for the Court of Appeal to take judicial notice of available resources elsewhere in the region?
Yes, Your Honor. As I see that I'm running out of time, would I be able to
you go
request-
ahead, answer.
Thank you. Yes, they are right in taking judicial notice. They are a supervisory court. It's the Ontario Court of Appeal. They know the number of courtrooms within the region, within the jurisdictions.
How do we know they know that? Isn't that just presumption? Isn't that just a perception? With judicial notice facts, the ones that judges introduce on their own without their ever being tested, the fact of available resources was never tested at the trial before the trial judge. The Court of Appeal just introduced that fact on his own. And the risk you run with judicial notice facts is that you can be wrong. how do we exclude the possibility that the Court of Appeal was wrong in finding that there were available resources elsewhere?
As it is the Ontario Court of Appeal's authority in this matter, as like I mentioned earlier, they are a supervisory court. We cannot, again, speculate that the Ontario Court of Appeal judge, Mr. Justice Lowers, was incorrect and that he would have known how many resources were available, how many courtrooms were available, if they could have accommodated the trial. We just don't know. The problem at hand today is that the Crown did not make the phone call, did not make the attempt for us to know whether or not those resources were available.
But once you concede that Justice Lawyers was speculating, then you've lost the point, haven't you?
No, Your Honor.
He relied on that fact in his decision. You've now undermined it. How can his decision continue to stand when there's no longer a valid foundation for it?
Respectfully, Your Honor, I am not stating that Mr. Justice Lowers made a mistake by any means. However, when an Ontario Court of Appeal does take judicial notice, they do know the region, they know the facts of the case. He was able to state that there were 10 courthouses available within that jurisdiction.
Wasn't the trial judge closer to the local conditions than Mr. Justice Lowers?
Yes, however, the trial judge also failed to analyze the reasons for the delay appropriately, did not put enough weight on the prejudice that can be inferred as a result of this delay. The trial judge only analyzed the inferred prejudice, but only gave it very minimal weight in the matter.
Okay. Do you have anything else?
Just my conclusion, Your Honor.
Thank you.
Your Honors, as you can see today, the delay was so lengthy that that prejudice must be inferred in this matter. It was not a complex case before the court, and the length of the delay went unappreciated by the trial judge. It exceeded the Morin guidelines by almost double what is tolerated by our justice system and by our society. A 35-month delay can only allow a reasonable person to infer that prejudice is significant. To do anything else today to Mr. Kenneth Gavin Williamson is unreasonable.
Thank you.
Barring any further questions, those are my submissions. Thank you.
Thank you. Go ahead.
Good afternoon, Honorable Justices of the Court. As my colleague mentioned, my name is Tang, T-A-N-G, initial C, and today I will be addressing society's interest in having Mr. Williamson's individual rights under the Canadian Charter of Rights and Freedoms upheld. Although there may be a societal interest in having Mr. Williamson's trial heard on its merits, in this case, the respondent submits that there is a far more important interest in upholding Mr. Williamson's individual right to a fair trial within a reasonable period of time. My submission today is twofold. Firstly, that Section 11B of the Canadian Charter of Rights and Freedoms seeks to protect 3 separate interests. And secondly, that the length of the delay was so incredibly long that under those 3 protected interests of Section 11B, when balancing society's interest in seeing this trial proceed on its merits and Mr. Williamson's individual rights, the rights of the individual trump society's interests. Firstly, under Section 11B of the Canadian Charter of Rights and Freedoms, it states that all those accused of crimes have the right to a trial within a reasonable period of time. Justice Sapinka, in the decision of Regina versus Morin, states that Section 11B seeks to protect 3 interests. First, the security of the person. Secondly, the right to liberty. And third, the right to a fair trial. Justice Sapinka goes on to state in that same decision that even the least fortunate of citizens, indeed those who are accused of crimes, for the respondent, Mr. Williamson submits, those who are accused of crimes are the least fortunate of citizens, have the right to be treated humanely and fairly. The security of the person interest does not only protect the physical security of an individual. As my colleague stated in her submission, security of the person includes the psychological security as well. Mr. Williamson suffered a 35-month delay that is significant, far beyond the guidelines set out in Regina versus Morin. The guidelines state that there is a maximum or a guideline of 8 to 10 months at the provincial courts and 6 to 8 months at the Superior Court of Justice, which can be considered a reasonable delay. It is the respondent, Mr. Williamson's submission, that having to suffer through a 35-month delay is not only unfair treatment, but it is inhumane treatment. This leads into my second submission, Your Honors. The length of the delay was long. As mentioned, it was 26 months of institutional delay allotted by the Court of Appeal. This violated his security of the person interest. In paragraph 74 of the Regina versus Morin decision, it states that the accused is not required to expedite his trial. It is not his obligation to do so. The Crown has a positive obligation to see to it that Mr. Williamson's security of the person interest is upheld.
But doesn't the Morin case also say that there's some onus on the accused to demonstrate actual prejudice? And what you're asking us is really what I heard from your friend, your colleague, was simply that the factors such as they are create an inference of prejudice.
That is correct, Your Honor.
And so then I come back to the same question that I had for your colleague, which is that, and again, appreciating that you were not trial counsel, but based on the principle in Morin, should trial counsel not have brought forth some actual prejudice, some evidence of actual prejudice? And on that basis, the failure of the accused to do so, doesn't that perhaps render the trial judge's decision correct?
Yes, Your Honor.
Or to put another way, to take from my colleague, Justice Ferranti, not such a palpable and overriding or unreasonable error to have been disturbed by the Court of Appeal.
Yes, Your Honor. In any instance, having actual prejudice would assist the court in determining that an unreasonable delay did occur. However, as stated in the case law, and excuse me, Your Honors, if I may ask for your indulgence while I look for this specific quote. In the decision of Regina versus Godin, in paragraph 38, the Honorable Justices of the Supreme Court of Canada stated that actual evidence of actual prejudice is not necessary to establish an inference of prejudice. The analysis set out in Regina versus Morin does not require the presence of actual evidence. It is the authority of the Supreme Court in this case to make an inference of prejudice based on the length of the delay. Mr. Williamson suffered through a 35-month-long delay. As stated in the case of Regina versus Williamson, the case at bar, the honorable justices of the panel themselves indicated that this delay was long and it exceeded the Morin guidelines. They drew an inference, or they drew a distinction, a parallel, between the case at bar and the case of Regina versus Steele. In Regina versus Steele, as my colleague mentioned, they indicated that the explanations for the length of the delay was inexcusable and unsatisfactory. In that case, the Court of Appeal found in favor of the stay of proceedings. Justice Corey, in the case of Regina versus Askoff, goes on to state in his decision, in a seminal case on Section 11B, that there is no greater frustration, indeed it is exquisite agony, for those innocent persons accused of crimes and awaiting their trial to prove their innocence. For under our Canadian Charter of Rights and Freedoms, all those accused of crimes are innocent until proven guilty. My friends mentioned that when balancing society's interests and the interests of the individual, the severity of the crime must be taken into account. It is not the respondent's position in any way to diminish the severity of the charges laid against Mr. Williamson. However, the Canadian Charter of Rights and Freedoms is a document entrenched in our Constitution. Our Constitution is supreme law. It is afforded, the rights of the Charter are afforded to all individuals, all members of society within Canada. If your honorable justices today rule against our client, Mr. Williamson, not only would you be found violating Mr. Williamson's individual right under Section 11B, but also the rights of society, as all society is granted that protection under 11B.
All right, let me interrupt you. I have a question. Your friends are urging us to overturn the Court of Appeal decision and restore the conviction. And I didn't ask the question of them, but I'm going to ask it of you. Tying into your suggestion that he's innocent until presumed guilty, or sorry, presumed innocent until proven guilty, apologies. Is it open to this court today to determine that we're going to overturn the Court of Appeal decision, but rather than restore the conviction, is it open to us to simply send this matter back to the trial court for a fresh trial? And I suppose, to be fair, assuming the Chief Justice doesn't disagree, I might like to hear from the Crown on that as well.
Your Honor, it is a submission of Mr. Williamson, the respondent, that under a violation of Section 11B of the Canadian Charter of Rights and Freedoms, and again to reference Justice Sapinka in Regina versus Morin, the rights afforded to individuals accused of crimes are very, very important. It is the position of the respondent that to do anything other than apply a stay of proceedings in this case would not be sufficient. The application for the stay of proceedings was granted or was submitted to the court prior to the trial. This right seeks to protect individuals before attending trial. Therefore, to send this matter back to the trial judge for another trial would be extending the delay even longer. It would increase the prejudice even further and further violate Mr. Williamson's rights.
Okay, thank you. Chief Justice, do you, oh, sorry, go ahead.
You don't ask for a new trial. The Crown doesn't ask for a new trial. The only issue before us is whether the delay was unreasonable. And if you win on the unreasonableness, it never gets back to a trial court. If the other side wins and says the delay was reasonable, it never gets back to a trial court. Isn't that the answer to the question?
I notice that I've run out of time, Your Honor. May I have a few more moments to answer your question? To be brief, Your Honor, the answer to that question is yes.
All right.
If If I may, excuse me, sir.
Do you want some more time to summarize your
Yes,
argument?
if I may conclude.
Okay, you go ahead.
The respondent acknowledges that there is a societal interest in having a trial heard on its merits. However, when weighed against the individual's rights under the Canadian Charter of Rights and Freedoms, the severe length of the delay that Mr. Williamson experienced indicates that the amount of prejudice inferred is significant. Therefore, today, the respondent seeks to dismiss the appeal and uphold the Court of Appeal's stay of proceedings. Barring any other further questions, Your Honors, those are our submissions.
Thank you very much. All right. Thank you to all counsel for your submissions. The panel is now going to take some time to deliberate over the decision, and we'll be back upon our deliberation. All right.
Hi, everyone. If I could just ask everyone to please take their seats. The judges have very quickly made their decision. Just quickly, as you're all getting settled again, my name is Tara Lazowski. I'm a member of the steering committee. We just wanted to take an opportunity to thank you all so much for volunteering your time. The competitors, the judges, obviously my volunteer team. I'm a little bit biased, I'll admit. Thank you so much for giving up your time. It is beyond generous and more than we could have ever expected. This weekend was just amazing, and we are so thankful. It's due to each and every one of you, your willingness, your commitment to the paralegal community, your desire to improve access to justice within Ontario, and a love of education. So thank you so much for being here and being a part of the 2015 Paralegal Cup. We will now welcome in the judges.
Do you want to start at this end, or you want to go?
We've decided the case, and the decision will be announced later.
Next week.
To allow us time to leave the building. No. That's just the way the organizers want it to be done. So we'll defer to them. But we've decided to make ourselves available to give you some feedback. And maybe not all of us want to give feedback, but we'll find out. Mr. Singer.
All right, so first of all, I think I speak for all of us when I say you guys ought to be really commended, and not just the finalists, but everybody that participated. You guys did a great job. I think all of us, those of us who have appeared as and I've appeared as a lawyer in court for 23 years, and I have seen, and this is the second year I've seen paralegal students who are better on their feet than an awful lot of lawyers that I see on a daily basis. And that makes me very, very happy for the future of the legal profession. A couple of points that directed at all of you. Judges are writing. They're listening to what you're saying. We want to hear what you're saying. Slow down. If you notice the judge is writing, stop. When I'm in court and I see the judge writing, until she's finished writing, I stop talking. Because there's a reason they're writing, and that reason might be beneficial to you. So they shouldn't have to ask you to repeat yourself. Secondly, answer the questions. The judges will, in most cases, in most courts, the judges will have read your materials before you get on your feet to make the argument. And the reality is that if they're asking you a question, it's because that's what they need to know. They might understand something else. They're asking the question for a reason, not to be difficult. We were asking it just to be difficult. But in real life, the judges are asking it for a reason. Don't put them off. Don't say, oh, I'm getting to that in a minute, okay? Address it right then and there. It's perfectly acceptable, as I think all of you did, to say, may I have a minute to answer that, and flip to the place in your notes where you have it. Perfectly acceptable. Not acceptable to say, Your Honor, I'm getting to that in a few minutes, but first I want to finish this point that you interrupted me on. And lawyers do that. I've seen it done in the Court of Appeal. Needless to say, that lawyer lost. My last comment would be simply this. There's no need to repeat your point. I know that you have a script and you all got to your conclusion, but I found by the time you got to your conclusion, you'd already made that point a bunch of times and it was sort of redundant. But other than that, great job.
I don't have much more to say than Justice Singer. I'm going to mirror his comments. I found this, all of you, with respect to court decorum, were very professional, very articulate, a lot of passion and strengths in your arguments, and it was very well received.
Any feedback on this side?
Just overall, for me, seeing both these teams in front of me today, I know I did also see you yesterday, and I commend you again for the improvements, the comments that we had given you yesterday. I saw some great improvements in what we had said, so I'm glad that you took it to heart and actually you did something with it. For everybody, same thing, great eye contact, good tone, good pace, good responsiveness to our questions, and overall, well done.
So I concur, actually. There was definitely some improvement from yesterday. I had the pleasure of seeing you guys yesterday, I think first up, and a big improvement. So it's nice, it's part of the learning of this process. One of the things that I can't help but wonder as I sit here is why the heck aren't paralegals in div court? I mean, seriously, look at the caliber of the look at the caliber of the arguments, the professionalism that's been before us, certainly now and through the course of this weekend, and you know, absent of any specific comments, that's what I've actually been wondering about for the last 15 minutes. So.
I commend all of you, not only the ones that made the finals, but all of you, for even undertaking an exercise like this. It could be very intimidating. It can be very challenging to understand the case and to withstand some hard questions from a panel. And you all did very well, I have to say. You withstood hard questions extremely well, to a lesser and greater extent, and that'll be reflected in our decision as to who won the moot. But you all did, in general, you all did very well in withstanding these hard questions. I found that all of you were very well informed as to the facts and the law that this case engages. You were very fluent with the nuances in the facts and the nuances in the law. I'm going to give a couple of comments, not on stylistics, not on the formal requirements, but mostly on content. It's too late to incorporate this feedback that I'm about to give you on content into this moot, but strive for the next time to incorporate these things. The first is simplify the case. I'm not saying to make it simplistic because these are hard cases and they're not simplistic, but you have to simplify the case and you have to reduce it to its essence, to the very core of it. And this case, from my point of view, reduced to one concept, and that was the concept of deference. On one side, the court was being urged to reinstate the trial judge's decision because he's entitled to deference on findings of fact. He's entitled to be wrong, so long as he's within the range of reasonable outcomes. And the other side is forced to argue that no deference should be allowed, no deference is justified because the trial judge's decisions were unreasonable. They fell outside the range of reasonable outcomes. So strive for this deep understanding of the case. And then when you're organizing the moot, just put forward one or two simple ideas that you're arguing. Very specific, very surgical. Get controversial right away. Ms. Tang, you didn't get controversial right away. You gave us like 4 or 5 minutes of totally uncontroversial material. The importance of the charter, the importance of 11B, the purposes that 11B protects, the kinds of interest. See, they're all non-controversial, and you could have saved yourself 4 or 5 minutes to make the arguments that are being contested. See, none of the things that you started out with were being contested. So get right into the argument, launch right into the argument. One or two more things. Stay away from your script as much as possible. And I wasn't here yesterday, but based on my prior experience, I would think that the competitors were more reliant on their scripts yesterday than they were today, and that comes with the familiarity, the greater familiarity of the arguments. I especially like the way you engaged the panel in question and answer period. These moots ought to be a conversation with the panel. You should welcome questions because they sort of signal what's troubling the judge. So he's laying it out to you. He's prepared to be persuaded. And you should take that opportunity to persuade him on that particular point. I like the way during these periods of engagement you had good eye contact and you relied not on your notes, on your script, but on your deep understanding of the case, and I appreciated that. Maybe one more thing, and this won't help you for next year's moot because it's specific to the legal issue raised here. Everyone argued the case that I heard today on the basis that the length of the delay, that the case turned on the length of the delay. This case doesn't turn on the length of the delay, especially the respondent side. The length of the delay was so long that it needs to be corrected for, that sort of thing. The case turns on not the length of the delay, but the length of the permissible delay. It turns on what the constitutionally acceptable limit is. And for every case, that's different. Where you draw that line is different in every case, and it's always driven by this exercise of discretion. and in turn is driven by the factors which drive the exercise of discretion. So you have to concentrate on the factors that drive the discretion. Place your limit, constitutional limit, and then depending on which side you're on, one side will say, we're to the south of that constitutional limit, and therefore we get to win as Crown. The other side will say, no, the actual delay was to the north of the acceptable delay limit, and therefore the accused has to win. That's all to say that you need to identify the issue on which the case is going to turn. That's not an easy thing to do. That's very difficult to do. But you should start getting into the practice of reducing a complex, data-filled case down to its essential issue. And then you have to obviously understand what the legal rule is that governs that issue. And then you apply that legal rule to the facts. I commend you again for just doing it. It takes a lot of courage to get up there, even with your back to the audience. And so well done.
At this time, we'll ask your honors to take a reserved seating out of the audience while we do a transition into the awards portion of the afternoon.
I'd like to start handing out the awards. So let's get down to business, shall we? Sure. The first one I'm going to hand out is the Written Memo Awards. And this particular award is donated by Edmund Montgomery, which is a textbook publishing company. They've also introduced a prep course for the paralegal exam.
Montgomery also publishing the new SABS desk reference book written by me, coming out in December.
So clearly a credible book. Thanks, Daryl. Anyway, the winners are Alexandra Portney. Excuse me. I'm an idiot. I'm so sorry. Oh, Fallon, indeed. I'm wrong. I read off the wrong one. I need to invite Kara Jacobs and Aaliyah Ahmed Osmond from Algonquin Careers Academy. They won. I'm so sorry. Two sets of stairs. Sounds like it. Is that from Congratulations. Thank you very much. Following my notes, I'd like to invite Elaine Page up for the next few.
So, Fallon Burns, oh no. Before I do this, I just want to congratulate all of you on such an amazing job that you've done. I'm so impressed and proud of each and every one of you mooters. And I also just wanted to take 3 seconds to say, hey, you guys, awesome job, way to go, and to give everybody who was part of organizing this a hand. So I have the pleasure of presenting the Oral Advocate Awards. So we're going to do this in descending order. So in 5th place, if I say your name wrong, I apologize. Shelley Brezen. Yeah. Yeah. There you go. You did it already. You beat me to it. In fourth place, Cathy Brklacich. I'm sorry if I got that wrong. Yeah. And in 3rd place, Anoop Kelsey. And in 2nd place, Alexandra Portnoy. Oh, come on up, come on up. Thank you. And now, as part owner of PrEP Network, Paralegal Resource Education Program Network, I would like to present the PrEP Network Award for Distinguished Oral Advocate, and that goes to Carrie Meager. Thank you. Can I have that? Yeah. Congratulations to all of you oral advocates. About a year ago, we lost a very dear member of our community. His name was Errol Sue. And I don't know how many of you in this room ever met Errol, but he was an extraordinary guy. He was a paralegal for probably somewhere in the neighborhood of 30 or 35 years, although one of the things I disliked about him is he looked 25. He was the epitome of professional and was well known for that and well respected for that. He sat as an adjudicator at the Law Society, and he was just an all-around amazing guy, and he was taken away from us far too young. So this next award is in his honor, and it is called the Errol Sue Award for Professionalism, and with it comes a wonderful trophy. And Alexandra Portnoy, come on up. What?
Now, before we announce the winners, I'm sorry, you do still have to wait a little bit longer. We do have some exciting news this year from one of our community partner programs. Every one of our competitors from this weekend is going to be receiving a 6-month subscription of ULaw Practice. As I said, generously donated by ULaw Practice. This will be arriving shortly via email in PDF format for all of you to enjoy as congratulations for your incredible efforts this weekend. And at this time, we'd like to invite Nancy Miller to the stage to present the Michael Turvey Finalist Award.
Thank you. I'm also inviting Mr. Dinner. He is the person behind this award. I knew Mr. Turvey as a paralegal in London. He was very young in his profession. He came to us with a background as a union advocate, and he formally trained as a paralegal and was recently licensed not too long before his death in a tragic motorcycle accident last September. And so this award is to honor the students that have brought what he brought to the paralegal profession, which was an attitude of fighting for the underdog, making sure that his clients got every, no stone was left unturned. And he was also quite active on the paralegal message boards. He, if someone had a question about some area of law, he would research it and get back to the person. And he was very much putting a lot of emphasis on the profession, the professionalism, and making sure that everyone was treated and had the proper representation. A very strong advocate, and that is what we're honoring the team with for this award. And the Michael Turvey Finalist Award goes to Cathy Tang and Jenous Lorestani. Sorry, Lorestani. Sorry, thank you.
Okay, everyone, hold your breath. So, the winners of the 2015 Paralegal Cup from Seneca College, obviously, are Gavin, Phillips, and Kathyrn Brklacich. Congratulations. Oh.
Ladies, why don't you come in?
And adding to their already beautiful trophy collection from the Paralegal Cup, we're going to welcome up Cathy, Tang and Jenous Lorestani again.
Everyone stay up here and smile.
Let me know when. So ULaw couldn't be here in person. They planned to be, and he feels really bad. So he just texted me to announce that not only do the winners get ULaw access, the entire class from the winning team gets access to ULaw practice for 6 months. So he feels terrible he couldn't make it, but wanted to pass along that as well. Thank you all for coming out and supporting the Paralegal Cup. What a wonderful weekend. Enjoy, have a safe trip home, and thanks again for all your support.